Xong đúng.
Okay, maybe I've got him. This desk 194 768 768. Yeah. Maybe it's got in. Got it?
Good morning, ladies and gentlemen.
Good morning.
Good morning.
As we are, how are you? I'm very well, thanks. As we are about to begin, I have one housekeeping note to make before we begin the program. Let us all kindly mute our microphones to avoid interruptions until and unless you are making a contribution. Thank you for your kind cooperation and attention. Once again, good morning, ladies and gentlemen. My name is Matthias Ruziwa. It is my pleasure to be Director of Ceremonies for this virtual labor law reform conference organized by the Engineering, Iron and Steel Association of Zimbabwe a board which represents interests of employers in the engineering, iron and steel industry of Zim. I would like to extend a very warm welcome to all of you. We appreciate you taking time off of your busy schedules to join us today. We sincerely hope and trust that you're gonna learn a lot this morning as we look forward to a fruitful and engaging conference. Our distinguished guests, ladies and gentlemen, at this juncture, may I invite Mr. Cleopas Gessi, Managing Director of Leo Free Technologies and also Western Region Chairman of the Engineering, Iron and Steel Association of Zimbabwe, to give us an opening prayer. Over to you, Mr. Gessi.
Thank you, Mr. Rizio. Good morning to you all. Thank you for giving me this honor to allow me to speak to the Lord. I will pray. Father God, we come before you this morning. We thank you for the gift of life. Lord, we thank you that you've made this meeting to be possible today. Lord, we thank you that you have allowed the people to come through, the people with the ideas, so that they share with the industries what is happening. Lord, we thank you that those people that will be listening to it will be able to use this information to the advantages of our industries. With this, Lord, we honor you, we give you glory. In Jesus' name I pray. Amen.
Amen.
Amen. Thank you very much, Mr. Gessi. May God richly bless you. Ladies and gentlemen, to begin our program, we are pleased to have Mr. Patrick Mnyaradzi, the Engineering, Iron and Steel Association of Zimbabwe's Eastern Region Chairman, and also Managing Director of Devon Engineering, to deliver welcome remarks. Over to you, Mr. Mnyaradzi, sir.
Thank you very much, Director of Ceremonies, and good morning to you all business colleagues. I start by acknowledging the President of EISAZ, Mr. Mangena, the Vice President of EISAZ, Mr. B.V. Munatsi, EISAZ National Executive Council members here present, officials from the Ministry of Public Service, Labor and Social Welfare, officials from various national employment councils, officials from academic institutions, captains of industry, representatives from the media fraternity, Engineering, Iron and Steel Association members, distinguished guests, ladies and gentlemen. It is with my great pleasure to welcome you all to this Labor Relations Conference, organized by the Engineering, Iron and Steel Association of Zimbabwe. On behalf of the EISAZ National Executive Council, I wish to extend my special welcome to our guests who have taken time off their busy schedules to be here with us today. I would like to acknowledge the Acting Registrar of Labor, Mrs. N. Simango, Provincial Labor Officers here present, our friends Dr. Nzonzo from IIE, MSc, formerly Monash, South Africa, and Professor Chipo B. Hungwe, Executive Dean of Social Sciences at the Midland State University. May I also welcome General Secretaries and designated agents from various national employment councils, as well as labor officers here present. I would like to acknowledge all captains of industry, lawyers, and human resources practitioners who have joined this virtual conference today. Thank you to each and every one of you for being here with us. We also would like to thank our media partners who are here with us. Distinguished guests, ladies and gentlemen, as you know, on the 28th of September 2021, the government of Zimbabwe considered and approved the Labor Amendment Bill. This bill largely aligns the Labor Act with Section 65 of the Constitution of Zimbabwe, Amendment number 20 of 2013, and to be ratified international labor organizations, ILO conventions. It also provides for the rights to fair and safe labor practices, standards. At the second edition of the Engineering, Iron and Steel Association of Zimbabwe Annual Labor Relations Conference, held on the 2nd of November 2021, we were privileged to have the entire labor amendment bill unpacked by a young and dynamic lawyer from Lunga Investment and Corporate Attorneys, Ms. Tsitsi Mazikana. Ladies and gentlemen, following Tsitsi's presentation on the 2nd of November 2021, where she unpacked the labor amendment bill, focusing on the conference theme, labor relations, what's next? We received numerous calls from the public and our own members demanding that we immediately have another conference to discuss the following key specific issues emerging from the bill, which have huge impact on day-to-day employment relationships at the workplace. Notably, not in any order of importance, but number one, duration particulars and determination of employment contract, emphasis on fixed term contracts. Retrenchment and compensation for loss of employment on retrenchment or in terms of section of subsection 4A. Number three, non-payment of retrenchment package due to fraudulent, reckless, or grossly negligent conduct by an employee. Next one is maternity leave, followed by contracts for hourly work, labor broking, admission of new parties to employment councils, designated agents of employment councils, paid education leave, involvement of ministers in negotiations of collective bargaining agreements on an equal footing in statutory corporations, statutory bodies or entities, wholly or predominantly controlled by the state, employment code of conduct, and lastly, liability of persons engaged in unlawful collective job action. This occasion, ladies and gentlemen, therefore, is extremely important for us as we see it as a forum where we can have genuine dialogue on the crucial issues as this bill may be enacted into law anytime soon. I'm sure if you follow yesterday's Herald, this matter was actually covered. We would like to thank Tsitsi for answering to our call at short notice. In today's program, she will be supported by 5 panel speakers who are uniquely placed to speak on key issues envisaged in the labor amendment bill. I'm very glad we found a selection of them prepared to speak to you about these important labor relation issues. Our Director of Ceremonies, Matthias Reziva, distinguished guests, ladies and gentlemen, let me not take too much of your time. A very warm welcome again to each and every one of you. Please kindly note that we have allocated 60 minutes for questions and answers on our program after the speakers' presentations and the subsequent session of panel discussions. Therefore, please feel free to ask any questions or seek clarifications on specific areas of concern using the public live chat available on our Zoom platform, or by raising up your hand. Ms. Mazikana, together with the other moderators, will attend to all important questions from the audience. Before I hand over to Matthias, our Director of Ceremonies, I would also like to remind the audience, and especially our speaker and the moderators, to please strictly stick to our time schedule and not to let any session overrun. I sincerely hope you'll enjoy the discussions, and I thank you very much for your participation. Thank you. Over to you, Director of Ceremonies.
Thank you very much, Mr. Mnyaradzi, for the heartwarming welcome remarks. William Shakespeare was once quoted saying, "Good company, good wine, good welcome can make good people." Our distinguished guests, ladies and gentlemen, ladies and gentlemen, may we please keep our microphones muted until and unless we are making a contribution. Thank you. Once again, our distinguished guests, ladies and gentlemen, today we are here to discuss key specific issues emerging from the Labor Amendment Bill, which have huge impact on day-to-day employment relationship at the workplace. In this conference, employers, trade unions, and labor relations practitioners seek to understand key provisions envisaged in the bill, with a view to establish what the future of labor relations will be in Zimbabwe. Our speaker for today's conference has had a distinguished career as a labor law expert. She's an innovative lawyer, experienced in developing case strategies. She's an exceptional negotiator who was involved with the Employers Confederation of Zimbabwe, MCO's class action around the famous Supreme Court Zoa judgment of 2015. It's a judgment which exposed employers to a huge financial risk. She has a record of 95% success rate in representing employers in labor matters over the past 7 years of her practice. Ladies and gentlemen, please welcome Ms. Tsitsi Mazikana. Over to you, Ms. Mazikana.
Thank you so much, Mathias. Thank you so much, everyone, for joining this workshop. I don't know if I'm audible. If I am,
yes, you are, ma'am.
Yes, thank you. So following the presentation that happened previously here on this platform, I have received several requests that the members would want us to touch on the special aspects that affect the employment workplace directly. So today, my presentation is going to touch the aspects that directly have an impact in workplaces. So I will be mainly dealing with sections 12, 12C, 18, 18B, 58, 63, 101, 109, and any other provisions that may come up, which I would have seen to be directly impacting the employment structures. So maybe if we may start with section 2, I find section 2 very important in the workplace because it touches on the definition of gender-based violence and harassment. When the bill seeks to define what is it that the Act looks at when we are talking about gender-based violence and harassment at workplaces. So the bill expressly states that it is violence and harassment directed at persons based on their sex or gender, or affecting persons of a particular sex or gender disproportionately, and includes sexual harassment, violence, and harassment. So basically what we are looking at where we are in employment setup, anything that reduces some employees because of their gender is taken as violence or harassment and should be avoided at all costs in the employment. This definition is quite important to the employers because it needs to be included in the sexual harassment policy. So as a nation or worldwide, we are moving into a space where gender equality is encouraged or mandated on every employment structure. So we are called upon to have distinct sexual harassment policies that speaks to these activities, which reduce people's demeanor in workplaces because of their gender. So it is my call that if any employment structure does not have a sexual harassment policy, kindly work on it and include all these things to avoid being taken in litigation by employees because of sexual harassment and violence in workplaces. The next aspect is on protection of employees' right to fair labor standards, which is covered in Clause 5 of the bill and seeks to amend Section 6 of the Principal Act. This is a provision which seeks to extend the scope of a working area to areas which are outside the physical working space. With the incoming of the COVID-19, we've realized that most of the employees are now being called to work from home, and sometimes people go on trips, work trips, and the bill seeks to cover all those areas where anybody is involved in the work of any undertaking. So we are saying where employees are either traveling to work or from work on a work trip, or social events organized by the employer, or any other activity that is organized by the employer or being done in furtherance of the employer's activities, is taken as a work area. So employers need to take note of those areas, especially in their codes of conduct. So this will also need to be incorporated into our codes of conduct. Otherwise, we have futile disciplinary hearings when the employees would say that the activities happened outside the workspace, and the codes of conduct do not include that as covering a working space. So it's something that you are called to include into your codes of conduct, so that when you are holding disciplinary hearings, it will be clear and distinct that this area is covered as a workspace. This is also in alignment with the ILO Convention number 190, which speaks to eliminating violence and harassment in the world of work. So Zimbabwe is a member state to that convention, and we are adopting it. So it needs to be covered into our sexual harassment policies within the workspace, and also into our codes of conduct. It is also imperative that the provisions of the amendment bill introduce a penalty for contravention of this clause of harassment in a workspace. And this is a fine of level 12 or to imprisonment for a period not exceeding 10 years, or to both. So apart from disciplinary hearings that may be conducted for contravening this provision, the employee is also subjected to criminal prosecution for contravening of this provision. So there is also a need for employers to have awareness campaigns within the workspaces to alert the employees of the importance of abiding by the amendment bill provision, as well as the implications of contravening such. We move on to section 11, which is amended by clause 7 of the bill, that is employment of young persons. You will recall that from the previous workshop, we had indicated that the minimum age is 16 years. But I've seen that the gazetted bill seeks to clarify on that, to say that the employment of young persons is capped at 10 years. So if an employer seeks to employ a person who is between 2 to 10 years, you will be found guilty of contravening section 11 of the Labor Act, and there is a criminal sanction to it. So the bill is seeking to curb the employment of children who are below the ages of 10 years. So last time there was a question that what happens where people in the farms and yes, in the farms are employing these young people. So I'm now noticing that from 10 years and below, it is a criminal conduct to employ that young person, but from 11 years to 11 years going up, I believe that employers can employ those young children, but obviously there are some restrictions to the nature of work that is given to those young persons who are below the ages of 16 years. And the next amendment is to section 12, which is affected by clause 8. That is the duration, particulars, term, and termination of employment contract. So now we realize that the common law, which related to notice periods given to contracts, it has been excluded in the amendments. So section 12.4a is repealed, and now it is imperative that the employers note that the employment of an employee may only be terminated on notice on the following grounds. That is where you have a disciplinary inquiry, and there is a provision in your employment code that a disciplinary inquiry for misconduct is accompanied by a notice. And then there is also by mutual agreement in writing. Please note that the mutual agreement cannot be verbal, but it needs to be in writing so as to be recognized at law. And then there is also a case of fixed term contract. And in this case, there is no need to give notice, but at the expiry of that fixed term contract, if the employer is not renewing the fixed term contract, then automatically the contract becomes terminated. It is also important for the employers to note that an employment contract which is less than 12 months and is not for a specified task which may be completed before 12 months or not for a seasonal or casual work is prohibited by the amendment bill. So employers need to take note that where they need to employ employees on a fixed term contract, it has to be 12 months. Otherwise, the contract must be for a specified task which will be completed before the expiration of 12 months, or the employment is just for a seasonal or casual experience. So outside these exceptions, the contract that is less than 12 months is deemed to be a contract without limit of time. So this is very important for employers to take note of, otherwise they will be found wanting if an employee takes them to court. There is also a provision which the employers have sought clarity on, which speaks to the majority of employees being on a fixed term. So what the law is alerting the employers is that where the majority of the employees within an undertaking are on a fixed term, upon the expiration of any of those employees' contracts, they will be entitled to payment of minimum retrenchment package. So it is important that employers need to look at, their contract of employment. If we have more than 50% of employees on a fixed term contract, be prepared to pay minimum retrenchment package on the expiration of any of the employees' contract of employment. And it should also be taken that this provision does not take away the right of the employer to terminate fixed term contracts by dismissal through a disciplinary inquiry, and retrenchment and also sick leave provisions. And then there is also the amendment to section 12C, which is effected by clause 9. And this speaks to retrenchment and compensation for loss of employment. In terms of section 12.4a, this is the provision that we've just been talking about, the provision of termination on notice. So the Act provides that where an employee has been has had their contract of employment terminated in terms of section 12.4a, which is termination on notice, they will be entitled to minimum retrenchment package. And there are certain definitions which have been incorporated into this provision, which are important to any employer. And this relates to the capacity to pay, the employer. So when we are talking about the capacity to pay, we are talking of an assessment for any employer that has terminated the employment and is mandated to pay minimum retrenchment package in terms of section 12C. So that one is covered in the provisions, as well as the employer, which speaks to any person, entity, or trust that is a successor to the employer, whether domiciled or in Zimbabwe or not. So we will have situations where employers adopt employees from a shutting down company or whatever modes of transfer that would happen to employees. That successor to the original employer is taken as an employer of that particular employee. There is also the definition of minimum retrenchment package. It is now 1 month's wage for every 2 years saved, or a proportionate for every part of a year saved. So this will be the minimum retrenchment that will be paid by an employee unless better terms are discussed. But you will also notice that the bill introduces that even when the Act provides for minimum retrenchment package, you will also find that there is a provision where an employee can approach the retrenchment board to say that my employer wants to pay a minimum retrenchment package, but the employer is capable of paying more than the minimum retrenchment package. So you notice that you experience that much, and it is something that you need to be prepared for, because even when you allege that you are only able to pay minimum retrenchment package and an employee manages to establish that you can pay more than the minimum retrenchment package, you will be ordered to pay more than the minimum retrenchment package. So it is a call that attempts to be made to try and negotiate with employees whenever you intend to retrench them, so that you will not have backs and forths in courts where you are trying to prove that you are unable to pay minimum retrenchment package. It is better to retrench an employee on an agreement for a retrenchment package than to fight over it in courts of law. Now the bill also introduces a period that an employer needs to pay the minimum retrenchment package. So the period that is given is 60 days from the date of retrenchment package, from the date of retrenchment. So these timelines are very important, because if an employer fails to meet these timelines, then there will be penalties attached to that failure. And the employee can just take the employer to the retrenchment board, and they will get a certificate of non-compliance, which may be confirmed in the labor court and then taken to any court of competent jurisdiction to execute that minimum retrenchment package. So this has a direct impact on the employer, as we want to avoid attachment of properties in execution of minimum retrenchment packages, and executions will affect the smooth moving of businesses. Sometimes employees target those particular assets that would affect the day-to-day running of or the day-to-day running of business. So the procedure that employers need to take note of for proper retrenchment is outlined in the bill. And the employers need to take note of these retrenchment procedures so as to avoid nullification of the intended retrenchment procedures. And this is when an employer needs to advise the employees affected of its intention to retrench the employees, then follows the negotiation for better packages with employees or their representatives. And if there are no negotiations with the employees, then the employer gives 14 days written notice to the NEC or Workers' Council or the retrenchment board. And next, there is a provision where there are negotiations which are completed, 14 days notice to the retrenchment board, notifying of the terms of the agreement. And in the absence of that agreement, then 14 days notice also needs to be given to the employee or employees concerned. And the employer needs to give full details of the employees who are to be retrenched. And then there is a provision which I have spoken about where the employer has failed to comply with the timelines, and also fails to pay the minimum retrenchment package, where the employees can take to the retrenchment board the issue and get a certificate of non-compliance. And then where an employer alleges that they can only pay a part or they cannot pay a complete retrenchment package, they need to make an application in writing to the retrenchment board. And where they are alleging that they can only pay a partial retrenchment package, the partial retrenchment package does not have to be less than 25% of the full package. Then the application is filed either with the retrenchment board or the employment council, whichever is applicable in the undertaking. And there is need to provide evidence that is necessary to support the application. And this may include the financial statements or any other documentation that an employer may think that it will support its case. And that application shall be served on the employees. So the application needs to be filed with the retrenchment board and then served on the employees. Otherwise, the procedure would not be complete. And upon filing the application, the retrenchment board has 30 days within which to respond. Prior to the amendment bill, there was no provision which spoke to what will happen if a retrenchment board fails to respond within 30 days. But in the current bill, there is a provision that the employer may appeal to the labor court within a further 21 days after the lapse of 30 days. So also prior to the amendment bill, there was no sanction, no criminal sanction to the failure to serve the retrenchment board with the list of the employees and details that the employer needed to retrench. But with the current bill, it is now a criminal offense to fail to serve a notice, and the employer will be subjected to a fine of not exceeding level 12 or imprisonment of not more than 10 years or both. And for purposes of imprisonment, the prosecution or the police will take an employee or governing board that will be arrested and taken to court. So it is important that the employer needs to take note and comply with all these provisions so as to avoid criminal prosecutions for failure to comply with the provisions of the law. And we have clause 10, which speaks to amend. Pardon me, I lost my. I don't know what happened. Just bear with me a bit. So it is important that the employers need to take note that most provisions in the labor amendment bill have criminal sanctions attached to them. So the employers need to avoid breaching the law in these circumstances so as to avoid being unnecessarily dragged to criminal courts. And the clause 10 seeks to amend section 12C again, which introduces the non-payment of employment of minimum retrenchment package under fraudulent or misrepresentations or gross negligence or even reckless running of business. So we have a situation where the employers would just want to only retrench employees and rush to the retrenchment board to plead that they are unable to pay or they are incapacitated to pay minimum retrenchment package. So where such incidents are happening and an employee alleges that its employer has fraudulently misrepresented to the retrenchment board that they are unable to pay the minimum retrenchment package, there will be an inquiry into that incapacity to pay retrenchment package. And if the employer is found to have deliberately stripped the assets of the business in contemplation of retrenchment, or have carried on its business recklessly with gross negligence or with intent to defraud a person being retrenched, the retrenchment board will call for an employer to respond to these allegations, and the response shall be on affidavit and within a specified time that the board would have stipulated. If the employer does not respond within such time or gives a scanty response which is not adequate to address the allegations, the board will issue a provisional statement in favor of the retrenched employees, and the labor court shall confirm those provisional statements issued by the retrenchment board. So the confirmation proceedings will call the employer or any person who is cited in that confirmation, in that provisional statement, to give representations on the aspects and allegations that would have been raised. And the labor court is entitled to give the following orders, which is either a general declaration confirming that statement from the retrenchment board, or a specific declaration to the effect that either the employer or any person named is responsible for paying the minimum retrenchment package, either jointly or severally, one paying the other to be absolved, which means that if there are, let's say, four directors cited in the statement and the labor court finds in favor of the retrenched employees, the labor court may order that one director shall pay the retrenchment package and the other directors shall have a recourse of that director who will have paid shall have the recourse of seeking reimbursement from the other directors or from the company itself. So there won't be any defense raised by that one director to say that, but we are 4 or 5 directors within an undertaking, so we cannot be I cannot be made to pay on my own. So the labor court can also order anything that is that it considers proper, which includes the payment of costs enforcement of that liability. And if that general declaration is ordered by the court, then it shall have an impact. It shall have an effect of a court order that can be executed upon. So it is important that whenever employers are terminating contracts and need to pay retrenchment packages, they need to be as candid as possible in the processes where they are claiming partial or complete incapacity to pay retrenchment package. Otherwise, the impact will affect even the directors or employees within an undertaking. There is also the issue of maternity leave, which the employers have sought clarity on. In terms of the bill, there is a reduction of the duration of the period which an employee would have worked in an undertaking for them to qualify for maternity leave. Under the Principal Act, an employee would be entitled to maternity leave only if they have spent at least a year within in a company. But under the amendment bill, we have realized that even an employee who joins the undertaking today and the following month they want to go for maternity leave, they are entitled to take a maternity leave for a period of 3 months and on full pay. And there is no longer a limit of a number which under which an employee can take maternity leave. Even if they want to go on maternity leave every year for the duration of their employment, the company is mandated to pay them for a duration of 3 months on a full salary. So this needs to be taken note of in contracts of employment. It is important that all the contracts of employment need to be amended to include this, unless the contracts of employment were not specific to the terms of the number of periods that a female employee can take maternity leave. That contract of employment need to be aligned with the provisions of the amendment bill. Then there is also the contract of hourly work. We realize that there are employees who are on hourly employment contracts. So the employer shall not deny that employee who is on an hourly employment to take another employment for the hours that they are not employed by the employer. Also, there is a provision that has been inserted which prohibits hourly payments which cumulatively within 2 months will be under the minimum wage of the undertaking under the CBA. So if an employer hires an employee for, say, for 3 hours in a week, and in 2 months, the cumulative salary is less than that minimum wage, which is stipulated in the CBA, that employee shall be mandated to pay up the difference of what the employees earn, what the employees in that particular category earn, and the minimum wage where employees do not earn the minimum wage for a period of 2 months. Employers need to take note of this as well. And also there is this clause, which is introduced by the new section 18B, which covers the labor brokerage arrangements. We've come to a realization that most employers or most employees are hired through labor brokerage arrangements. And this is quite important for employers to take note of, that where the employer is hiring an employee through a labor brokerage or through a labor broker, the arrangement between the employer and the labor broker needs to clarify the obligations that each party has, so as to avoid situations where an employer or an employee's contract of employment is terminated and the employee does not know who to sue so as to get their dues. They may be the dues may be minimum retrenchment package, damages, or unfair labor practices. So this provision deals with a mischief that comes with triangular employment relationships, which circumvent employer obligations and responsibilities, including fair remuneration of workers. We've had situations where an employee is hired through a labor broker, and the employee is paid some package or some salary that is below the minimum wage of that undertaking, and the employer denies responsibility on the basis that they are not the ones who hired that employee, and they are only using an agent or a broker to hire that particular employee. This provision will jointly and severally place a liability on both the employer and the labor broker, unless the arrangements between the three parties is clear as to who becomes responsible when need arises. So it is very important for employers to take note of the arrangements that are there when they are hiring employees through labor brokers. There is also the formation of employment councils and admission of new parties, which is covered in clause 23, which seeks to amend clause 56. This speaks to voluntary employment councils. So in this provision, the employers' organizations and trade unions or any federation, they may form a voluntary employment council by signing a constitution agreed to them, and the effect of that constitution shall be through registration of that employment council in terms of section 59. And where that board or the parties who seek to register an employment council, which is on a voluntary basis, is registered, where that voluntary council is registered, the votes shall be apportioned between the employer and employee in equal numbers, and the registrar shall be responsible for determination of any disputes that may arise, as well as any failure of agreement between the parties within that voluntary council. And where the registrar fails to address the issues, then the labor court shall have the jurisdiction to determine any appeal that may arise. And section 56 also governs the admission of new parties to the employment council. So we may have employers who are not happy where they are, and they decide that they want to register an employer party or a federation that they would want to be a party within a voluntary NEC. The procedure is governed under section 56 of the new Labor Act to come. And then there's also the section 63, which deals with designated agents. So it is a new development that the labor bill introduces, where designated agents are no longer empowered to just visit employers where there are suspicions that there is any offense that the employer may be committing within an undertaking. Prior to the amendment bill, a designated agent would just come to an employment undertaking and do their investigations or seize any property which they believe that is a subject matter of an offense. That right has been taken away by the amendment bill, and also that bill introduces a provision where there is a dispute that has been filed with the designated agent for redress. The bill allows any aggrieved party who feels that 30 days have passed and the designated agent has not addressed the grievance that has been raised, to take up the matter with the labor officer. So the jurisdiction of a designated agent is ousted after 30 days of failure to address an issue that has been presented to the NEC. But within the 30 days that a dispute has been lodged, the labor officer's jurisdiction is also ousted, and there is exclusive jurisdiction of an NEC where the undertaking has an NEC. So at the expiry of the 30 days, the aggrieved party would take up the dispute that has been earlier on lodged with the NEC with the labor officer within the Ministry of Labor. And where the labor officer has taken up jurisdiction, has assumed jurisdiction after the period of 30 days, the provision that covers this scenario is introduced in clause 25 of the amendment bill. This clause also introduces a grievance procedure where an employee or an employer feels that their matter has not been properly dealt with it at the NEC and seeks that designated agent's appointment be withdrawn. So the procedure set out is introduced by section 3C, which speaks to the procedure that the registrar receives a complaint from an interested party that a designated agent has failed to exercise their mandate effectively, and upon receiving that complaint, either the registrar or a labor officer makes an inquiry, and during the inquiry, every party concerned shall be given an opportunity to make representations. And if these representations found to be in favor of the complainant, then the labor officer or registrar shall withdraw the appointment of a designated agent. And if the complaint is in relation with an ongoing dispute of unfair labor practice, that ongoing dispute shall be seized forthwith, and the registrar may direct that the matter be allocated to a different designated agent or be referred to a labor officer. So this clause also is important wherever a dispute is ongoing within the NEC, so that the employers or employees can make complaints where they feel that their matters are not being handled professionally or properly or in a fair manner. They may take the matter up with the registrar for an inquiry into that allegation, and a proper decision may be taken for that. The clause seeks to bring justice in handling of affairs where a dispute has arisen. And then there is also section 74 of the Labor Act, which is amended by clause 26, and this speaks to the introduction of paid education leave. So it is mandated that the parties to a CBA negotiate the payment of education leaves within an undertaking. So it is now mandatory that every education leave be paid within an undertaking, and that has to be incorporated into a CBA. What I would recommend to employers when negotiating for paid education leave within a CBA is that they negotiate with a bias towards studies that enhance their undertaking in a department that the relevant employee is placed. We would want to avoid a situation where, for example, an accountant within an undertaking seeks to take a paid education leave for studies in a marketing department or in a law field. That does not enhance the employer within a department that the employee is placed. But it is important for an employer to say that fine, we will pay the education leave, but the education that an employee is undertaking must be aligned to their duties and to what they are employed to do. So this will curb the situations where an employer will find themselves with a bleeding or a hemorrhage of employees after having their education paid for. It is also important for employers to consider bonding their employees upon completion of their paid studies. For example, to say if an employee is undertaking in a 6-month course and that 6 months needs to be paid by the employer may say that upon completion of your studies, we will bond you for the following 6 months so that they will recover the monies that they have paid for that employer's enhancement through the employer's through the employee's employment of their expertise that they would have gained in their studies. So this is a very important aspect that the employers need to take note of when negotiating for paid education leave within a CBA. And then there is also the issue that comes into play, which is very crucial, the issue of employment codes of conduct. There is an introduction of a payment of a mandatory fee for registration of an employment code of conduct, which is introduced by the bill. The employers also need to take note that they need to periodically review every registered employment code after 5 years. So the effect of not reviewing the employment code of conduct is that that code of conduct shall be deemed to be unregistered. And the employer shall then have to revert to SI 15 of 2006. So the employers need to take note that at the lapse of every 5 years, they need to look at their employment code of conduct and check if there's anything that needs to be amended or addressed. And I have those amendments or that employment code of conduct re-registered after the expiry of every 5 years to avoid proceeding to disciplinary hearings or grievance procedures using an expired or unregistered code of conduct, which will expose the employers to unnecessary litigation by employees. And then there is also the amendment which speaks to liability of engagement, liability of persons engaged in unlawful collective action. So the clause only seeks to create a distinction between the liability that is attached to people who engage in unlawful job action in a case where essential services are involved in any other case. The major change that has been brought is the penalty that, that is attached to these two groups of employees. For the employees who are in essential services, the penalty is stiffer as it is pegged at a fine not exceeding level 14 or to imprisonment for a period not exceeding 5 years or to both. And for any other employee, the penalty is a fine not exceeding level 14 or imprisonment not exceeding 1 year. So the distinction is to imprisonment penalties. And then there is also the test that is employed for the criminal sanction, which is that the person who is engaged into that unlawful collective job action has realized that there is a real risk or possibility that their conduct might bring about the collective job action. Then section 112, it just clarifies the offenses and penalties that are included for and the penalties that are included in the Labour Amendment Act. That is the contravention of section 104, subsection 3, which is engagement in unlawful job action, and section 105, which speaks of lockouts and actions connected with such lockouts, and another provision that is in section 106, subsection 2b, which is contravention of a direction that one needs to show cause order, or the terms of a disposal, contravention of the terms of a disposal order. So the provision seeks to introduce a criminal offense which is pegged, which penalty is pegged at level not exceeding of a fine not exceeding level 14, or to imprisonment for a period not exceeding 5 years, or to both. This is for employees in an essential for essential services, and in any other case it is a fine not exceeding level 14, or imprisonment not exceeding 1 year. So in conclusion, these are the issues that I have noticed that affect the employers, particularly in their employment, in their day-to-day activities. So what I've realized is that there is much of criminal sanctions to contravention of the employment of the provisions that have been introduced by the amendment bill. So it is important that for employers to avoid being found on the wrong side of the law, there is a need to amend their contracts of employment with the employers, to amend their disciplinary and grievance codes of conduct, to also introduce or amend their sexual harassment policies. And as we have realized that the amendment bill has been gazetted and it is a law that has already come upon us, we need to be wary of that. And it is important to note that these contracts of employment, codes of conduct, and sexual harassment policies need to be amended, reviewed, and put in place and in alignment with the law with immediate effect. Otherwise, we will be faced with another 2015 situation where we have class action against the employers over non-compliance with the amendment bill, which is the situation we will also want to avoid at all costs, because it does not bring about good business within the undertakings. And I am pleased to announce that I am available whenever you, as the employers, wish to have assistance in your contracts of employment, codes of conduct, sexual harassment policies, and any other policies that may need to be addressed, working with your employer organization, Engineering, Iron and Steel Association of Zimbabwe. So we come to the end of our presentation, and over to you, Chair.
Thank you very much, Tsitsi, for an enlightening and entertaining presentation on specific provisions of the Labour Amendment Bill. We appreciate having all the key areas of concern clarified, insights on such key areas as fixed-term contracts, retrenchment and compensation for loss of employment, issues to do with maternity leave, labor broking arrangements, employment codes of conduct, and paid education leave is especially useful as companies plan to embrace the oncoming labor law. The audience may not know this, Tsitsi, but we owe you a special vote of thanks for being here, because I happened to find out that you asked a colleague from your law firm to attend to a very critical Supreme Court matter so that you could make it. We really appreciate that. our distinguished guests, ladies and gentlemen, it is more likely that you have many questions for Tsitsi, but just to give her a break while she prepares to answer your questions, we have a panel of 5 experts from the Labor Relations and Business Fraternity, which shall discuss key issues arising from the Labor Amendment Bill. Allow me at this juncture to hand over this part of the program to our session moderator, who will also take us through the questions and answers session. She is an Associate Fellow, Australian Academy of Business Leadership, Chartered HR Professional, Learning and Development, SABPP, designated AAP practitioner, and is an academic at IIEMSA, formerly Monash, South Africa. Ladies and gentlemen, please welcome Dr. Jennifer Chishami-Sonzonzo. Over to you, Doc.
Morning, colleagues. I trust that I find you well today, and greetings to everyone and all protocols observed. Thank you to EISAZ for hosting this very informative session. We need more of such sessions. And I want to thank Tsitsi for re-unpacking the Labor Amendment Bill again. You did a wonderful job for the previous conference, and hands up to you. So, ladies and gentlemen, what we're going to do now is we are going to have panel discussions. We have about 5 panelists who are going to give their views around the Labor Amendment Bill. So immediately afterwards, then we're going to have the question and answer session. Each panelist has roughly around 7 minutes to give their views and insights. So what we can do during their presentations, their insights, kindly post your questions to the chat forum. Alternatively, you can actually have a discussion immediately after they have presented. But if you post to the chat forum, I'm going to be jotting down all the questions again. So right now, I'm going to introduce our first panelist, who is Mr. Moment Bebe. Mr. Moment Bebe is a lecturer in the Department of HRM at the Midland State University. He has research interests in the domain of employment and labor relations, skills development, and employee engagement. He recently finished reading for his doctoral qualification with the University of South Africa, UNISA, focusing on developing a bipartite social dialogue framework for enhancing collective bargaining in the Employment Council for Engineering, Iron and Steel Industry. Moment, congratulations are in order in advance. So I'm going to hand over to you, Moment. The floor is yours.
Thank you, Jennifer, and good morning to everyone. Can you hear me?
Indeed.
Yes,
Thank you
we
very
can
much.
hear you.
All protocols.
Yes, I can hear you. Yes, you can go ahead.
Thank you very much. All protocols observed. It's a good morning to everyone. And once more, we meet for this crucial labor relations conference for EISAZ. I'm privileged to be associated with each and every one of you present. Thank you, Tsitsi, for taking us through the bill. I've been tasked to comment on 2 aspects, the amendment to Section 18 on maternity leave, as well as the amendment to Section 12C on retrenchment. May you allow me to first begin with the amendment on Section 18 on maternity leave. I believe that the amendment is pretty straightforward, as was anticipated in conformance with the Constitution. The repeal of the provision requiring female employees to have served a year for them to qualify for the paid maternity may be seen as promoting greater social justice and inclusion for female employees in the world of work. And of course, the doing away with the provisions that restrict and cap the exercise of this right in terms of the intervals, as well as the number of times that a female employee can exercise the same right with the employer, we may see it as a 360-degree departure from what we had become accustomed to. So I think this is a considerate legal move, which is pretty sound and well-intentioned. It indeed advances fair labor standards for female workers and promotes One would say it also promotes their full participation in the labor market without any prejudice. Therefore, it is encouraged that employers adhere, as Tsitsi pointed out, to this particular section, and that they also do not get tempted to, if I may put it that way, to apply some Nicodemus tendencies to discriminate against prospective employees, female employees, in respect of job and promotional prospects. And as EISAZ and organizations within EISAZ thrive to become employers of choice, it is prudent that the employers work with the HR professionals to encounter within their people management practices that spirit of support for the female employees and career women who seek to enjoy their motherhood and contribute to the future needs for human capital. So overall, I believe that this is a well-intentioned addition insofar as the bill is concerned. Then, if you may also allow me to move on to the section 12C on retrenchment. We observe that there's been a repeal, as Tsitsi has pointed out, to section 12C with regards to the retrenchment regulations. Two forms of retrenchment packages have been spelled out, being the minimum retrenchment package and what we will now call the enhanced retrenchment package, which is a product of negotiation and agreement by the primary parties to the employment relationship. This is, there's nothing new here since the 2015 amendment introduced these. However, an important point to note relates perhaps to the payment of the retrenchment package, where a time frame for the payment has been introduced. There is, I believe, there is some form of flexibility in terms of the payment of the retrenchment package with respect to the retrenchment notice, and also the opportunity for employers to engage their employees and pen out agreements for a longer or staggered payment kind of a system. I would like to think that the intention here precisely is to promote
Moment, I'm not sure if I'm the only one. We seem to have lost you. Colleagues, can you hear Moment?
No,
No,
we
we
can't.
cannot.
No.
Not anymore.
Oh my goodness. So what we can do in the meantime, while we're trying to get Moment back, there was a question posted by Tafadzwa Omera. I'm sorry, Tafadzwa, somehow I got cut off. I couldn't get hold of your question. If you may just repost your question. But Shelley asked a question a little bit earlier on. The question is, what will be the criteria for selecting one director among the other directors? So Tsitsi, I think this one is for you, but any of the panelists is welcome to answer.
Okay, I will take that question. So let me explain what will happen. So what happens is, where an employee has taken, say we have A, B, C, D directors within an organization, and the employee takes all those 4 to court. Then there is an order that the sheriff may execute on these people's assets. So what happens is the sheriff may execute on any party's assets that they may find. So we have situations where directors or people have their assets hidden in trusts or in companies or anyway in other people's names. So what transpires there is, where an employee has that order which is executable against A, B, C, and D jointly and severally. So the sheriff may just find the property or even a house that is registered in B's name, and the sheriff will attach that property and sell it in execution. They will not listen to the fact that the but there are 4 directors within an organization. The recourse that B has to their property is that they will just go and sue A, C, and D so that they recover their portion of a liability. So it's really not about a criteria or to be used, but it's about whose assets are available immediately for execution. What the judgment debtor or the judgment creditor or the employee is just concerned with is getting their money and nothing else. So basically, that is the issue around the principle of jointly and severally, one paying the others to be absolved.
Thank you, Tsitsi, for clearly explaining that. Much appreciated. Then I'll just take one more quick question. Gilbert has asked, has the bill passed into law as yet?
The bill has been gazetted as of Monday, yesterday or Friday, I believe, but it's been gazetted now. So I think it's at the final stages of it being incorporated into law. What is just left is assenting by the president to just say it is now law, but I believe we are quarter to having it into law.
Thank you, Tsitsi. Sure. So what we can do, ladies and gentlemen, while we're waiting for a moment to get online back again, I'm going to move on to Mrs. Gladys Mupemba. Mrs. Mupemba, I trust that I find you well today. So Gladys is a holder of a master's degree in business administration. She is the managing director of NSC Labor Consultancy based in Bulawayo, which specializes in labor relations, HR, and organizational development. Gladys acquired more than 15 years of experience as a senior labor officer in the Ministry of Public Service, Labor and Social Welfare, and has served as a government-appointed independent arbitrator for several years. Gladys conducts worker education programs in East and Southern Africa for Commonwealth Trade Union Council, and also she's got vast experience in drafting HRM policies and employment codes. She is the current chairperson of the National Employment Council for the Grain Marketing Board. Ladies, the floor is yours.
Thank you, Jennifer. Good morning, everyone, and thank you for having me. I'll get straight to business. I've got 3 sections that I need to zero on. One is also on maternity leave, which Moment is going through again, and NCT has also adequately addressed. But I just want to add and say that this section 18 has been amended so that we align to section 65, subsection 7 of the Constitution of Zimbabwe. Take note that the breastfeeding periods of 1 hour will continue in terms of section 18. So employers must take note of that. As has been said before, no more limited periods, no more qualifying periods. So female employees should not be discriminated. Employers must continue to engage female employees and make sure that they also enjoy the new changes that have come to section 18. I need to move to the other section on code of conduct that employers now need to register code of conduct and also make sure that you pay, there's going to be a prescribed fee which will be paid for registration of code of conduct. What's important is to note that the Works Council codes of conduct still have to be approved by the relevant NEC before they go for registration with the Ministry of Labour. So ensure that if you want to come up with a workplace code of conduct, it has to be approved first by the NEC, then escalated for registration. The codes of conduct, as has been stated by Tsitsi, and which is in the bill, they have to be reviewed after every 5 years. And after review, you have to, within 3 months, the code must be sent through to the Ministry of Labour. If not, the code will be deemed deregistered. And therefore, you will have to either implement SI 15, which is the National Code of Conduct, or you have to use the industrial code of conduct if it was a workplace code of conduct, but only for the categories that are covered by the specific code of conduct. The other section that I want to look at, which has also been looked at, that's the one on section 12. I've observed that section 3A has not been repealed or amended. That's the one that gives the employment councils the liberty to negotiate a collective bargaining on contracts of employment. For example, I'll give an example that in engineering industry, I know no employee can work for more than 3 years on a fixed term contract. So what it then means is the NECs would have to sit down again and look at how their CBAs are drafted in terms of timeframes. Because I know certain CBAs that would say no contract is less than 3 months and so on. These would have to be changed because the bill is stating no contract should be less than 12 months. So any contract should be 12 months or more. And one other thing that we need to realize is there is also a section that's stating that an employee is deemed to have terminated his contract only by resignation and by retirement. We need to discuss whether an employer cannot retire an employee, because for what the employer can, how an employer can terminate the contract of employment, retirement is not there. The question now is, do we have to revert to pension rules in terms of retirement, NASA Acts, or a contract of employment? So we will discuss as we get into the questions. Thank you. Back to you, Jennifer.
Thank you, Gladys, for the very insightful comments on that. So, ladies and gentlemen, what I'll do, I'm going to move on to the next panelist. And then in the meantime, I'm still collecting all the questions that are being posted in the chat forum. Our next presenter is Mr. Patrick Muchovo. Patrick is a holder of 2 master's degrees in business administration and strategic management. I wonder how you did that, Patrick. You should share the secret one day. He has a vast experience in industrial relations in both the private and the public sector. He is currently the Senior Local Joint Committee Secretary for the NEC Engineering, Iron and Steel Industry. So Patrick, the floor is yours. Over to you.
Thank you, Doctor. All protocols observed. I would like to thank the previous speakers for a job well done. Let me also start with the intended amendment of Section 18, which is dealing with maternity leave. I'm quite in agreement with what has been presented by Moment Bebe and Mrs. Mpemba. But my worry, which I then want to present to the employers here present, is on the unintended consequences that the section you will have to come up with. The limits have been done away, and it therefore means that is in as many times as possible, a female employee may take maternity leave on full pay. In terms of business operations, this will also then means there will be costs that are going to be accrued by employers. One, for paying the employee while on maternity leave. And secondly, there will also be additional costs, because while that employee is away, the employer will have to find a cover for that employee. Therefore, I think business has to be prepared for these additional costs. And I would also then just encourage that this is coming, and it may be so good that also even the CBAs are aligned to speak to this, so that the earlier raised fear by Mr. Bebe that Nicodemus standards may be brought about. There has to be some ramifications where it can be proven that an employee has been discriminated against based on the pregnancy. That would be my first contribution on that. Then also allow me then to move on to the amendment that is intended on section 63. Before I go further, I'll just want to note an observation that I have, which I think would be a point of departure from the presentation that was presented by Tsitsi. I think we may have to relook at it. In her presentation, she mentions that section 63, subsection 3, paragraph B, has been repealed, which takes away the right of a DA to enter upon any premises of an employer in the undertaking. I think let's relook at that, because from my reading of the bill, I think what has been repealed is section 63, subsection 3, paragraph 3B, rather than section 63, subsection 3B, which therefore means that the designated agents still have the right to enter in upon any premises of an employer in any undertaking or industry. Because if this is taken away, it therefore means that the DAs will basically then be redundant, will become redundant. Okay, thank you. Just passing through there. And then secondly, quite a number of issues come here. For so long, we have known the designated agent to be at par or on the same level with the labor officer. The bill is bringing in some connotations where the labor officer is beginning to be regarded as maybe superior to the designated agent. In one, a labor officer can now raise a complaint against a designated agent. A matter can now escalate if it's not dealt within 30 days by a designated agent to a labor officer, which I think, in my view, the ministry may have approached this in a wrong way. In that the ministry should have just ensured that they've got the mandate to enforce that NECs become efficient. Because escalating matters to labor officers, we all know that already is before even they take upon these cases, they are already overwhelmed. They are under-resourced, and we are also not provided as to if a further delays then happen at the level of the labor officer, what then happens to the case. Moving on, also the 3C, the registrar may also now, after noting some affording a designated agent an opportunity to present their side of story over complaints that may have come, they may withdraw the appointment of designated agents. I think it's good in a way that the industry has been provided with an opportunity to, where they are not happy, they now have somewhere to report. But also I then get worried again with the unintended part of it, because there are also questions that still arise when a designated agent has been withdrawn by his appointment has been withdrawn by the registrar. What then becomes the status of that designated agent in terms of the particular or relevant NEC which has employed him? And also what happens when there is a disagreement, when the particular NEC is in support of a designated agent and the ministry is saying we are withdrawing. I think these are all questions that we may need to discuss and see what is really intended to be done. But by and large, I see this also as a positive development in that it will ensure that there is expeditious dealing of cases, in that no designated agent will sit idle on cases. And I think as NECs, they may need then to ensure that the designated agencies are protected to come up with the standard operating procedures that ensure that the 30-day period will not lapse before cases are attended to. Those are my view on section 63. And lastly, I'll move on to section 74, which is dealing with the scope of collective bargaining agreements. In that, there has been an introduction for paid educational leave. I would agree with
Sorry, Patrick, for interjecting. If you may kindly wind up. Thank you.
Thank you. I will agree with the previous speaker in terms of employers preparing to negotiate, and also in addition with what she has said in terms of bonding, I would also encourage that there will be also a qualifying service to say an employee will qualify for educational leave after serving for a certain period. Thank you. I hand over back to you.
Thank you, Patrick, for the very insightful overview and analysis. Much appreciated. Moment we lost you along the way, if you may just kindly finalize your panel presentation for the next 3 or 4 minutes. Thank you. Moment, can you hear us? Okay. In the meantime, I'm going to move on to the next presenter. Our next presenter is Frank Marara. Frank is a holder of a Bachelor Honors degree in Human Resource Management. He's a business executive with 13 years corporate experience in managing human capital, sales, legal, financial, and operational issues in high-performance organizations in the manufacturing sector. He is the current general manager for Shepco BMA Fasteners Private Limited and sits in the Code of Conduct Appeals Committee for the NEC Engineering, Iron and Steel Industry. Frank is also a member of the Confederation of Zimbabwean Industry, CZI, and actively participates in the CZI Maternity Chapter Chamber. So Frank, over to you. The floor is yours.
Thank you, Doc. All important guests on the platform, a warm welcome. I'm just going to look at 2 issues. The first issue that I'm looking at is the codes of conduct. I think Gladys has already done a wonderful job there, so I'll just zoom in on a few areas touching on codes of conduct. My observation, obviously, you have heard that codes are now expiring after 5 years. My immediate comment there is on the administrative burden that this new amendment brings with it. Firstly, what will happen to pending disciplinary cases when the code of conduct expires? I also heard Gladys talk about parties relating to SI 15.
one then wonders if SI 15 is itself exempt from the expiry tenure. If it does expire, this I foresee what we call a legal lacuna, a lacuna in our law, where pending cases on expiry of codes of conduct are left hanging without any legal instrument to finalize them. So that becomes an issue. I think it will create an administrative a challenge there. Another issue there administratively, will the Ministry of Labour have the capacity to re-register all expired codes of conduct? That to me will present a challenge, and perhaps it's coming in as a critique on my end. My recommendation would have been the law should have then made it mandatory for parties to sit and review and not allow come up with a provision where codes should expire. The law should have just come up with a provision where it is mandatory for parties to just sit and review codes of conduct, and thereafter the parties would deem it necessary whether it should be re-registered or not. You know, sometimes you have the pains of renewing a code of conduct which has not expired. You know, that administrative process may be cumbersome to the ministry. That is my notation on codes of conduct. My other area that I was handling was collective job action. This one, our anchor presenter dwelt much on this. I just want to note that, you know, strikes are never encouraged. In any economy, they are disruptive. You don't aspire to be a developed country or developing country with clear growth trajectories, and your laws are supporting strikes. So I'm with the amendment. My notation there is, I have noted in other jurisdictions, particularly France, they have individualized the right to strike, and our laws are making it a collective right. I would be more inclined to a situation where, as a country, as also one of the methods to stifle strikes, make it an individual right. It means if I, as an individual, wants to go on strike, I should be able to go solo. Why should the right be collective? I think in a nutshell, those are my issues. Maybe let me just touch on one issue on codes of conduct. There is also the jurisdiction of labor officers. As you are aware that previous court judgments have attacked the jurisdiction of labor officers to entertain handling of completed disciplinary cases. We see as an amendment to section 101, a move by the legislature to allow labor officers to hear appeals. You would also understand that the current provision is that labor officers were only allowed to do draft rulings, which we had to be confirmed at the labor court. So this new amendment is quite welcome. It will remove the bottleneck or the clogging of cases at the labor court, because labor officers can now conciliate and hear appeals. In a nutshell, I think other provisions were touched by previous presenters. That's my presentation, Doc.
Thank you, Frank, for the insightful overview and analysis. Much appreciated once again. Moment, I'll have to slot you in again after Takunda has presented, because we seem to be not to be getting you again. Takunda, the floor is yours. I'm just going to give an overview of Takunda Mayedzenge. Takunda is a holder of a bachelor's degree in human resource management. He's currently practicing human resources as a human resource management manager for Hagiran, Zimbabwe. Takunda has more than 20 years experience in human resource management. He's a part-time human resources consultant and a board member of the Institute of Sustainable Project Planning, Monitoring and Evaluation. He sits in the Code of Conduct Appeals Committee at NEC Engineering, Iron and Steel Industry, where he also serves as the chairman for the Finance, Investment and Procurement Committee. Takunda, over to you.
Thank you very much, Jennifer. A warm welcome to distinguished guests here present and all the participants on this forum. I had been tasked to look at Section 8, which seeks to amend Section 12 of the Labor Act, and also look at the amendment to Section 58 on admission to new parties to the Employment Council, and on Section 18A with regards to contracts for hourly work. I will start with the amendment to Section 12 on duration, particulars, and determination of employment contract. I have got a few observations that I have made there, and concerns which I think previous speakers, particularly Tsitsi and Gladys, have touched on. The first observation, I think Gladys also mentioned it. It's only Section 4A, where retrenchment has been classified as a prerogative of the employee only, where it says a contract of employment may be terminated only on the part of an employee by his or her resignation or retirement, which means, and nothing on termination on the part of the employer has looked at retirement. So it's kind of worrisome that an employee may reach a retirement age, be it 60 years or 65 years, and choose not to retire. And then what does the employer have to do in such circumstances? The person is old, and there is need to bring in new blood, and the person has decided not to retire upon reaching retirement age. Previously, the employer would just notify, the practice was that the employer would just notify an employee that has reached the retirement age, and ask them to fill in the required forms and leave. Now it's a bit different and a bit tricky. I think it should be up for panel for discussions on this forum. Yes, the second issue that I have noted, there's no need to give notice on fixed term contract, but I think this has always been one way or the other obtaining. And most contracts of employment have a clause to that effect, that there's no notice. Once the fixed term contract is expired, it is expired, unless the employment contract is terminated. The fixed term contract is terminated mid-term. Then there is a provision which I think Tsitsi also touched on, but we, as employers, we need to take note of and put measures as quickly as possible in order to accommodate it, which is to the effect that a fixed term contract shall not be for a period less than 12 months, unless it's for a specific service, or it's a casual work or seasonal work. So that's an area where we need to ensure that we address it as quickly as possible. But I think I will leave it again to this forum to discuss what specific service would really encompass, or what specific service means, and who defines that this is specific service, and so forth. And following that is the provision that a fixed term contract of less than 12 months shall be deemed to be a contract for indefinite period. So it means we may, if we are not careful, we will end up having permanent employees by default. And then there is a provision which talks about where a situation where an employer is more, the majority of employees in an undertaking are more than are on fixed term contracts, and it says that such employees are entitled to minimum retrenchment package on expiry or on termination of contract. So in my view, I think it is segregative on the part of those employees on fixed term contracts who in an undertaking where maybe 49% or even 50% of the employees are on fixed term contracts, they will not be entitled to this right. So it's a bit tricky, and also given that it's something which can be abused by employers by just ensuring that maybe 50% of their employees remain on fixed term contracts, or 49%, just to be safe, 49% remain on fixed term contracts, and the rest are on permanent, employed on permanent basis. Then I move on to section 50, amendment to section 58 on the admission of new parties to the Employment Council. On that one, there isn't much observation that I have made, except to comment that there is some general thinking that the trade unions in Zimbabwe are not apolitical. They have been associated with trade, with politics, since we know that they are basically two mother trade unions, which is the ZCTU and the ZFTU. And maybe in some quarters, they think that the formation of ZCTU, of ZFTU was a political move. It's not me saying that, some quarters say so. And I just hope that given that background, the unions will be able to work together and not disturb the business of the NEC, because obviously there will be some internal politics, and also in terms of representation, they would also need, because what we can see now is that there will be unions coming to the NEC from ZFTU affiliated unions and other unions from ZCTU affiliated unions. Previously, ZCTU has been enjoying participation in NEC business since at the time NECs were introduced. There was only one mother trade union, which was the ZCTU.
Apologies,
Yes.
Takunda. Sorry for
Yes.
interjecting. If you may kindly wind up. Thank you.
Okay, then I'll move to section 18A. On that section, I've just noted, which with regards to contracts of employment, I have just noted that the amendment effectively may violate some conflict of interest provisions in some employment contracts, where employees are now allowed to work, and they can choose even to work for business competitors when they are working outside their stipulated working hours. With that, I thank you very much, and over to you, Jennifer.
Thank you, Takunda, for the very insightful and critical viewpoints. Much appreciated once again. Moment, do we have you back again? They say that technology never loved us sometimes. I hope technology is going to behave this time.
I agree. I had to change the laptops. Can you hear me?
Loud and clear.
Thank you so much. Just one or two observations in respect of section 12C on the procedures for retrenchment. I believe that the procedure aims at promoting a rather more transparent and detailed approach to retrenchment in respect of the minimum retrenchment package as well as the enhanced retrenchment package. And also the fact that the employer still retains the opportunity to apply for exemption within specified timelines and procedures is actually key to creating some form of equilibrium, you know, in the genuine circumstances that the employers may be facing, as well as the need to ensure a dignified exit for the retrenched employees. However, perhaps the catch will be the process for resolving the non-payment of the retrenchment package appears rather taxing and bulky. You know, you have the whole section on non-compliance certificate being issued. You have to approach the labor court for enforcement. You also have to register from the labor court, and then you also have the insertion of the new section 12cc, where the process may again be seen to be too cumbersome, with employers having to be held personally liable for paying the retrenchment package. I'm wondering how long that process may take ordinarily, and what it may also take to ensure that they initiate the investigations to prove indeed that the employers would have conducted their businesses in a manner that is fraudulent. That is my take. Then also one more thing is on the introduction of the sexual harassment, gender-based violence and harassment and violence in the workplace. I think that's a pretty great move, given the past evidence that has been gathered in terms of research activities in Zimbabwe by the Ministry of Women's Affairs and also by independent researchers in Zimbabwe, such as Memory Ngui, where they espoused that gender-based violence and sexual harassment were on the rise, and therefore having such provisions within the Labour Act introduced is a right step in the right direction, except that now it is prudent for employers and employees at workplaces and at the industry level to try and conscientize each other, employees and management, and also inculcate that kind of a sense of belonging and cohesion, you know, amongst employees within the establishment. I think that's one strong aspect that the Labour Act, the bill is introducing. Thank you very much, Tsitsi and Jennifer.
Thank you, Moment, for the critical insights. Ladies and gentlemen, now we're going to move on to the question and answer section. So what we're going to do, I'm going to be alternating between those who want to express their views via Zoom, what do they call it, via the voice option, and then those who have posted their comments in the chat. So I'll be alternating between the two. So right now, if you have any question that you want, you can raise your hand. I can just take note of you and then I'll give you the floor. But I'm just going to start off with one question that has been raised by Nyasha a little bit earlier on. This is open to the panelists. So Nyasha's question is, some employers argue that the 6 months for breastfeeding hour begins when you start breastfeeding your child during maternity leave, right? Therefore, when you come back to work, you only take the remaining 3 months for breastfeeding hour, not 6 months. What is the correct position on this? Panelists, this is over to you. And Tsitsi included again.
Okay, Jennifer, can I answer?
It's okay. Gentlemen or ladies first, make a choice.
Ladies first.
Thank you.
Okay, cool.
Right. I actually meant to respond to it when I was commenting on section 18. The female employee has to enjoy the right when they are back to work. They can only enjoy that because remember, there are some employees who go on the 98 days of maternity leave, and then they will extend by taking part of their vacation leave. So imagine an employee has been away from work probably 5 months, and we cannot say they've already enjoyed the benefit when they are home. The female employee has to enjoy the benefit when they are back to work. So the 6 months of breastfeeding will commence when the employee is back to work from maternity leave. Thank you.
Awesome. Thank you so much for that clarity. And that's a very critical point in terms, especially in just taking care of our employees on the wellness side and also on the welfare side. Thank you so much for that. I don't see any hand that is up. I'm just going to
Sorry,
move
Jess.
on to the next question. Is there anyone who wanted to add on?
Yes, I wanted to just add on
Oh,
that
thanks,
and
Bishop.
say that the Labour Act is very clear on that aspect. It's covered under Section 18, subsection 8. It specifically says during normal working hours, during a mother of a suckling child shall during each working day be granted at a request at least an hour or 2.5 as she chooses during normal working hours for the purposes of a nursing child. So it's very specific. It is when she's back at work. Thank you.
Thank you for the affirmation. Much appreciated. I do not see a hand up unless the hand icon from my, oh, Nyasha, over to you. Nyasha, over to you. If you may kindly unmute, we can't hear you.
Hi, Jennifer. No, thank you for responding to my questions. Answered. Thank you so much.
Thank you, Nyasha. There's another hand which is up. Oh, this is Nyasha. I'm going to move on to JV. JV is asking a very pertinent question here. Have we managed to finally align the labor bill to the provisions of Section 65 of the Constitution of Zimbabwe? Very good point you're raising there, JV. Panelists, over to you.
Yes, can I take that?
Yes, Titi, over to you.
Okay, sure. I would say we have managed to cover a greater ground in aligning the Labour Act with the Constitution, because the provisions of Section 65 have been attended to. So we'll find that a lot of issues, or if not all of them, are well covered in the amendment bill. So I would say all the issues have been addressed in the amendment bill, because in Section 65 we are looking at the right to just remuneration, safe work environment, just remuneration. That's where you see the safe labor practice, fair and safe labor practice and standards, which have been included in the bill. The right to safe work environment, it's always been covered. The right to join trade unions, it is provided for. Right to strike, that's collective job action, and right to strike, it has been covered as well. Right to safe work environment, again, that is satisfactory, equitable, and just conditions of work. We have been capturing all that. And there's also the right to join trade unions, except for security services. And you've noticed that there is a provision which we covered in the previous workshop, where we said that all there is the issue of compulsory work, excluding the security services. That is covered as well, job collective bargaining. And there's also the issue of women and men having a right to equal remuneration for similar work. I have seen it covered again in the amendment bill. Then the topical issue, women employees having a right to fully paid maternity leave for a period of at least 3 months, that is also covered. So I believe that every aspect has been covered in alignment with Section 65 of the Constitution, which speaks to labor rights.
Thank you, Titi. Much appreciated.
Just to add on, Jennifer, perhaps the participant may have particular aspects that they want clarity on, but we also appreciate that the Labour Act sets the minimum floor of standards, and nothing stops the Works Council or Employment Council level to also better some of these provisions that are specified in terms of the Act, as long as they are not inconsistent with the Constitution. So I believe, like what Tsitsi has said, a lot has been covered. Particular circumstances may be dealt with at company level and also at the industry level. Thank you.
Thank you so much, Moment. Much appreciated. I'm gonna move on to Tafadzwa. Tafadzwa, I have two of your questions. If you can also cover them in the voice questioning part aspect so that we can just, then we'll move on to K Moyo and his question. Tafadzwa, over to you.
All right, thank you so much, Jennifer. So my first question was on what happens in the case of civil civil society organizations, NGOs, on contract duration, where the contracts are based on donor funding. In cases where a donor wants you to employ people for a certain period, maybe for 3 months, and they cover a certain aspects, and then you are given another grant, which is also 3 months. How then do you draft the contracts to align with this new labor bill?
Panelists, over to you. Panelists, over to you with regards to the question by Tafadzwa. Is asking about the case of the civil society and the donor funding, which is less than 12 months, maybe for example, 6 months. What is the position on the contract on that? Tafadzwa, I hope I've managed to succinctly capture your question there.
Yes.
Okay, maybe I may attempt to address that. If you look at the Labor Amendment Bill, it has specific exemptions to which the 12-month period or expiration period of a fixed-term contract apply, which is where the job that needs to be done is seasonal or casual, and that what needs to be done will be completed. The job that needs to be done will be completed within a period of 12 months or less than 12 months. So those are the only exemptions that are covered by the Labor Amendment Bill, unless there is a specific law that covers civil societies, which will exempt the civil societies from complying with the Labor Amendment Bill. Then the provisions of the Labor Amendment Bill will apply with equal force to civil societies where the contracts are less than 12 months. So you find that there is either the contract, either the work that needs to be done will be completed before the expiration of 12 months, or that it's a seasonal or casual work. Otherwise, if not that, you will have to pay a minimum retrenchment package.
Wow, interesting.
Thank you, Titi. Any other comments from the panel, from the panelists on the matter?
Yes, Jennifer.
Yes.
There were two people that want to comment. Okay, whoever goes first is fine.
Mr. Mcho, you can take it.
All right, thank you. It's just in addition to what Titi has said. So the question was, so how do you draft the contracts? It means that if it becomes a task-related contract, which then has to be specific that the employee is employed for this particular task. And when then that task is completed within a period less than a year, then you will be fine. But if it then therefore means that I think the point is the task has to be defined in the contract so that you then become covered, so that you then don't be moving employees from one task to the other. Thank you.
Thank you. I'll take one more comment on that. Any additional comments on that? Thank you.
I think I'm okay with what Mr. Mcho has just said. That's exactly what the way I wanted to express it.
Okay, perfect. So I'm going to take the next chat question and then I'm going to move to K
Sorry,
Moyo.
you said I can ask the second question. So the second question is
you
on
had
maternity.
about 3 questions. Yes, you can go ahead. Yes.
So the second part was on maternity leave. That yes, it's a good initiative, But would that not then result in discrimination of our female counterparts, where employers will now be favoring to employ more males as compared to females because of this new maternity leave which is coming into effect?
They will be arrested, Tafatsgo, if they do that. I'll personally come from South Africa by foot and make a case for that. But anyway, panelists, over to you.
Can I come in?
Yes.
Yeah, I think it cannot be avoided because employers are different. We'll definitely come across employers who discriminate, who may even ask a female employee in an interview whether how many kids they have, whether they still want to have more babies, which is discriminatory because that has nothing to do with the performance of the employee. So I think employers need to be advised not to discriminate by asking such questions, because in the event that the employee then does not get the job, they may take it up in a different platform. So chances of discrimination and chances of not engaging childbearing female employees are very high, because employers would want to run away from the cost of getting a relief worker when the female employee proceeds on maternity leave. And we know that there are some establishments where we have a lot of employees, female employees rather, being in the majority in a workplace. So young female employees may run the risk of not getting engaged because of this issue of maternity leave. But because it is a right in terms of the Constitution, we plead with employers to respect that and to continue to engage female employees and allow them to enjoy their rights in terms of Section 18 of the Labour Act. Thank you.
Thank you for the clarity, much appreciated. Ladies and gentlemen, I'm just going to move over to the chat questions that we had. EISAZ, there's a question that is similar to Jennifer, so I think this should be addressed. Jennifer posted a question which is also similar to that. So the question is about the deregistration of codes after 5 years. The question to the panel is, according to SI 15, right? No different from any other code. As such, it will also face the same registration since it's more than 5 years old. What code are we then going to be using given the circumstances? I hope I've been able to succinctly capture that. The panelists, over to you. It's about the deregistration of the codes after 5 years. What code is going to be used?
Thank you.
Panelists.
If I may attempt.
Okay, don't worry, no attempts. We want you to expurgate, if I can borrow a term from my lawyer friends.
Yes, I think Mr. Marara touched on it, that a lacuna may be created. In order to avoid this, I think respective companies which have company codes, respective NECs will have to be proactive about it and ensure that preparations for renewal of employment codes are done in time. Because I'm sure also it does not mean that all the codes are going to be expiring on the same date, day and time. So much that the ministry will then be overwhelmed. So I think the encouragement is to employers and to the NEC just to be proactive, because if it expires, definitely it would have expired and it cannot be used. Thank you.
Thank you for the clarity, much appreciated. Panelists, any other comments on that? Before I move on to K Moyo, I'm sure his hand is tired now. He or she, the hand is tired now. They've been raising their hand for some time.
Yes, hello.
Yes, to you.
I need to clarify that I believe that section 101 relates to employment codes of conduct, which are registered by either an employment council or by an employer organization. My interpretation of this 5-year expiration period specifically excludes SI 15 of 2006 because it is not an employment council code or an employer's code. It is a national employment code of conduct. So I would like to believe that the lawmakers expressly intended to exclude it from being reviewed after 5 years, but rather it is those employment codes of conduct that are registered pursuant to an employment council or an employer. So I would also want to just jump into the question that arose, that will our ministry be able to comply with this provision that it will be re-registering these employment codes? I've noticed that there is an introduction of a payment of a fee. So I believe that this is to cover for that that exercise where there will be registration and deregistration of employment codes. But I'm not sure about the practicability, the practicality of it, when we are saying, will we be able to cope with all the industries and organizations' employment codes of conduct? So maybe I've touched 2 questions that one, the SI 15 is not covered by section 101, and the issue that the payment of a fee that is prescribed may also have an effect of covering the exercise of re-registering the employment code.
Thank you, Tsitsi. Just a question from my end. I just want to find out, in terms of the re-registration, what happens if, in terms of the re-registration, right? And then there's a very serious overhaul, like literally they've changed 90% or 80% of the elements of the codes. What implications is that going to have in terms of the workplace? Because there are a lot of aspects that are involved in terms of conscientizing the employees about the code. So I'm just thinking around that issue of those drastic changes. What does the law say about that in terms of the registration?
Well, I think that is a lacuna that has been created by this bill, because unless the ministry is going to set rules that will govern the negotiation or the reviews of these codes of conduct. But I believe that a 5-year period is sufficient time for employers to conscientize their employees, and also also trade unions to conscientize their members when the reviews are due, because I believe that there is also an extension upon expiration, which is about 3 to 6 months, I think. So maybe we are looking the practical aspect of it. Maybe we are looking at, say, the employer is aware that their codes of conduct are expiring in 2022. You may need to have at least about 6 months before the expiration date to start engaging the employees on the aspects that are proposed to be amended, so that all the parties will be on an equal footing, and the aspects that need to be amended will not materially diverge from the norm that the employer is accustomed to.
Thank you, Tsitsi, for the clarity. Much appreciated. I'm just going to move over to Kay Moyo. The floor is yours.
Okay, thank you, Doc. Yeah, my question is on the proposed amendment of section 12, where it reads, if the majority of the employees engaged by the same employer on fixed-term contract at any time when employee's employment is terminated. My question is on, does it occur when an individual contract of employment has been terminated upon its expire, or when the majority of the employees' contracts have been terminated? I think I just need a clarification on that aspect.
Thank you, Kay Moyo. Panelists, over to you.
Can you
Yes,
come again? Okay.
Sorry.
I see Takunda. Takunda, yes,
Yes.
you can comment.
Yes, I think it's very clear where it says if the majority of employees engaged by the same employer on a fixed term contract, and at any time when an employee's employment is terminated on the expire of his or her fixed term contract, then the provisions of 12C and 12D shall apply to such termination as if it was retrenchment. So I think the wording there is very clear on expiry.
Thank you,
contract.
Takunda, for the clarity. I'm going to move on to Meconex Private Limited. The floor is yours.
Morning. I don't know if I done the right thing. Good morning. This is Yes, this is Meconex Private Limited. I've got 3 questions. My name is Nomsa. The first one is on the minimum retrenchment, which is 1 month for every 2 years worked, and then against the NEC gratuity. If the company is paying NEC gratuity, do they still have to go on and pay the minimum 1 month for every 2 years worked? That is my first question. And then the second question is, a company still allowed to send the 65-year, or when someone turns 65, to be sent on retirement without compensation? And then the third one will be the young persons who are 11 years and above. Which industries are allowed to employ those people? Because before it was 16 years for training and then 18 years on proper employment. And the banks up to now still don't give bank accounts for those that are less than 18. Thank you.
Thank you for the questions. Panelists, over to you.
I'll take the first one on the payment of retrenchment and gratuity and say that for the industries that have gratuity to be paid, this is paid irrespective of the reasons for termination. Retrenchment package is paid, as we may call it, compensation for loss of employment. So both get paid. When you retrench an employee, or other applicable terminal benefits get paid, mostly being gratuity and leave pay, and probably notice if need be. So that's the one that I just wanted to address. Thank you. My colleagues can take on 2 and 3.
Colleagues, the other 2 questions.
Yes, I'm not on these 2 questions. I just wish to add from where Greg is. It's just said that I wish to add that gratuity is usually associated with the pension. That's where the other substitutes the other, and not your retrenchment package.
Thank you for the clarity. We can move on to the third question. Panelists, over to you. Panelists, the third question about the industries.
I'll come again. I think when we talk of employment of young persons, if nothing is stated in the CBA of the relevant industry, we then fall back on the Labour Acts. We know that traditionally or customarily, we get young persons being employed, particularly in the agricultural sector. But if it's not mentioned in any of the CBA under which you fall, then we go back to the Labour Acts. And if you also look at it from a moral point of view or from a humane point of view, I mean, a child of 10 years, what type of work can they do? What type of work can they do? So I think we just also need to apply our minds and see the nature of work to be done, but let us be guided by the Labour Act and adhere to the ages that are prescribed for employment, unless if your CBA is very specific, because we're talking of over 53 industries. So it would be very difficult to mention and say this industry, yes, you can, that industry you cannot. Go back and check in your relevant CBA if there's anything relating to the same. Otherwise, the Labour Act should guide us. Thank you.
Thank you for that. Much appreciated. Ladies and gentlemen, in the essence of time, I'm just going to move on to some of the questions so that we try to make sure that we adequately address all the questions. EISAZ is asking a question about foreign direct investment. I'm going to combine this with their question again, which is almost linked in terms of the legislation. If the panelists can address both of the questions together, they're asking about, with the new labor changes, are we moving in the right direction towards FDI, foreign direct investment, as a nation, which will assist in achieving Vision 2030? Then the other question is about the legislation. It's sought to classify fixed-term contracts below 1 year as permanent contracts. If the panelists can just tackle the questions, both of them, and then we can move on to the next questions. Thank you. Over to you, panelists.
Okay, I will just maybe try to, I'm not sure what they refer to as foreign direct investment, but I also wanted to make a comment with regards to these labor laws, the existing ones, including this new amendment, in that it affects an employer. Let's look from an employer's perspective. I'll speak maybe from the point of view of leaves or paid leaves. In a particular year, we have got 30 days that an employer is obliged to pay in a calendar year for annual leave. There is 12 days special leave, and there is 180 days sick leave. And there is now there's this study leave, and then there are even public holidays which an employer is obliged to pay. On average, they are maybe 12 to 13 in a year, and then we add on to the 98 days maternity leave that female employees are entitled to, and all in all, you will find that maybe around more than 200, maybe 3/4 of the year, an employee can be on leave for 3/4 of the year and on an employer's pay. That is very expensive on the part of the employer, but generally we do not regard it in that light. We do not see it in that light if we are not the employer. But if we take that to the level of you as an employer for your gardener or a maid, then somehow we will understand how expensive it is. While we very much respect employees' rights and their rights to rest, to be on maternity leave and be paid while they are sick, but I think the burden is too much on the employer. Probably there was need to find ways where the burden can be shared somehow. So on its own, it discourages investment. Thank you.
Okay, thank you. Just to add on, we have observed that the fixed term contracting is actually increasingly becoming a permanent feature, in the world of work. So when I would think that the government is rather too prescriptive, in terms of the regulations associated with fixed term contracting. I'm not so sure now, I'm not pretty sure in terms of the extent to which the consultations with the tripartite partners were, because I believe that the law should have perhaps left it out to the parties at industry level. We still have industry agreements, we still have company agreements in respect of some of these provisions. Particularly, I'm looking at the fixed term contracting. We are aware that there are industries whose nature, of business would make it impossible for them to offer contracts that are long-term based or beyond 12 months. Think of it from the security sector, even maybe the engineering sector, we may have particular companies. Think of small, businesses and the NGOs, as someone else highlighted earlier on. I think it is rather too prescriptive. We should have left it out to, to the industry and the companies to, to make certain decisions with regards to some of the provisions. Thank you.
Thank you, Moment, for that. I'm going to move on to Dr. Avila Goba. If you can just highlight your viewpoints, and then the panel will get back to you.
Thank you so much, Dr. Zonzo. And thanks to the panelists and, of course, the presenters and the facilitator. I have two issues that have come to mind. The first one is that I think F. Marara alluded to the issue of the retirement age not having been looked at properly in this bill. So I wanted to pursue that matter in the context that we have, for example, the pension rules, of course, depending on the setup, and then we have the conditions of service, and at the same time with the contracts for employees. So in terms of the concern raised by Mr. Marara, I just wanted us to find a way forward or to what takes precedence, if I may put it that way. That's one. Then my second concern is to do with the fact that we are in an economy that is being run by SMEs. I think we're all aware of that. And these SMEs have also remained informal. So my question that I'll put to the labor experts is that, or the legal people, what does this mean in this world of work? Thank you so much.
Thank you so much, Dr. Avila. Any comment from the panelists so that I move on to the chat questions? Okay. Let me move on to the chat questions. Just a quick one. There's a question here. Yes.
Yeah, just an interesting from Dr. Avila. I think that's lovely. The issue that our economy is largely driven by the SME sector at present, and we are likely to see that in the long term. And the question will be, is there space for the SME in terms of these provisions of the Act? I think that's something that appears to have been, overlooked and rather generalized. I think that's an interesting observation. Unfortunately, they have to conform to what is available in terms of the provisions of the law, even if it means it would hurt the SMEs, particularly the formalized SMEs. Interesting. Thank you.
Thank you so much for the comments. Much appreciated. What I'm going to do now is, let me just move on to this question. Sisi, I think this one is for you from Kudakwashe, is that when do we start counting the 5 years to register the code of conduct? Is it from the time of initial registration, or from when, from the point that it was made into law?
Okay, thank you, Dr. Nzonzo. The calculation starts from the day that the bill becomes law, unless there is a specific provision that that has a retrospective application. But our law generally do not have a retrospective application unless expressly stated so. So the calculation begins from the date the law becomes effective. If it becomes effective if the bill becomes effective as law, say on 1 December, then that is the time that the calculation commences. Otherwise, most of the code of conduct would have already expired, so it will be difficult to implement. So it commences from the date the bill becomes law.
Thank you so much, Titi. And then the next one from Brighton. I think, Titi, you clarified this right at the beginning, because Brighton is asking about that this is still a bill. Isn't the process that it will now have to go to Parliament for debate before it is made into law? Titi, may you kindly clarify on that, because I certainly heard you talking about this.
Okay, yes, it is still a bill, but now that it is gazetted, consultations have already been ongoing in the industries, as I have seen in the communications, and I do believe that it is almost ready for being passed into law, because this is the second draft that is circulating. There was already a first draft, which was, I think, sometime last year in June. I can't remember quite well the time, but we are already quartered to having it passed into the law, and I'm quite confident that the bill will be assented into law very soon.
Thank you, Titi. And then Farah is asking about what happens to the contracts that have already been signed expiring after the bill has been approved. Titi, doesn't it align with your previous comment in terms of effective implementation? Can you confirm that for me, for us rather?
Yes, okay, now with regards to contract of employment, if you have gotten me correctly when I was making presentations, these contracts, they are ongoing, and they need to be aligned with the law, because once the law is passed, then it means that all that which was lawful previously, that has now become unlawful, have to be amended and reviewed, and so that they can conform with the provisions of the law. So, for example, if your contracts of employment were clear that the contract is a 6-month contract, and yet it is not specific, task specific or casual or seasonal, then you need to look into it again and say maybe to increase the period or to make it task effective, task based. But it doesn't have to be less favorable than it was. Otherwise, again, you fall into another problem. So basically what needs to happen is to look at all your contracts of employment and align them to the provisions of the law as they would be at the time of the assenting of the bill.
Thank you, Titi. I see a comment from Tafadwa. Whilst Amendment Section 18 is a very good call, also talks about discrimination. I think we have covered that already when there were comments by ladies about that we cannot control how the employers are going to recruit there. Then we have a question from EISAZ. How effective will be our dispute settlement mechanisms be given the new arrangement under sections 93 and 98 of the Labour Bill? Are we not going to have arbitrators overwhelmed with cases, whereas on the other hand, some of the arbitrators do not have adequate expertise to produce quality awards? Panelists, over to you.
Let me attempt to respond to that one. That I think we've walked that road before, where we had labor officers and DAs as conciliators, and then referring cases to arbitration. I think with the conciliatory skills that our DAs and our labor officers possess, there should not be any cases, that are many that will be referred to the arbitrators. I think the labor officers and the DAs would have to apply their conciliatory skills so that cases are resolved at that lower level before referring to arbitrators. And I hear a comment on arbitrators. It's not every arbitrator, and I think arbitrators go through the registration process where they are deemed fit and able to take on arbitration cases. So I don't think the arbitrators will be overwhelmed. And like I said, this is a process that has been done before, and we do not anticipate any problems. But after making comment on it, I think we still need to go back to the question that was asked about retirement, to say if an employee can retire and resign, can the employer still retire the employee? I think that question still needs to be responded to. But I think as far as arbitrators and labor officers are concerned, I do not foresee so many cases going up for arbitration, especially if the officers that initiate the conciliatory process are able to bring parties to an agreement. Thank you.
Thank you so much,
Come in
ladies.
as well.
Yes.
One also interesting observation is that in terms of dispute settlement, we have two parallel processes that have been ongoing. One, which is in terms of Section 63, where determinations, designated agents can issue determinations, and one of Section 93, where now conciliation and arbitration has been brought back. And the arrow points of greetings. Sorry, I am having a. So the one on Section 63 of issuing determinations has not been done away with, and it has proven to be more favorable in terms of how most DAs have been handling cases. I'm not sure why the two have not been married, but I foresee us having reduced cases going for arbitration, where most designated agents are most likely to rely on just issuing determinations. Thank you.
Thank you for that. Ladies and gentlemen, I'm just going to take one more person who wants to ask a question online, and that's Sibangani, and then I'm going to concentrate on the chat questions. And if you may also kindly check that maybe your question has been addressed a little bit earlier, because there are so many things that we have to address. And I would think that EISAZ will actually host another session again, because so many aspects literally need to be addressed again. I'll just repeat that. So Sibangani, your hand was up. May you kindly just share your question? Sibangani, are you still with us? Okay, I'm just gonna move on to Dr. Avila. You can share your question.
Sorry. Yeah, I think my question was answered. Please go ahead. Thanks.
Okay, that's fine. Then the next question that I want to highlight here is the fact that there's a question about the manufacturing sector by EISAZ, that the manufacturing sector is still classified as an essential service. Is this going to remain after the COVID-19 for the purpose of the implication of the provisions of Section 104 of the Act? Panelists, over to you. Panelists, the matter of the manufacturing sector.
Let me try and respond.
Sure.
And say that I think we in the Act, we know who essential services are. And because of COVID-19, they've been designated more essential services. So I want to think that after the pandemic, we would have to revert to the essential services as they are. My understanding is the essential services that were defined during COVID-19, it was because we wanted the economy to continue running, and therefore the shops, the manufacturing industry would continue in business, so that that would not negatively impact on the economy. But I think given the situation that things get back to normal, I would want to think that those current essential services would still be, I don't think they would continue as it were in terms of the section on collective job action. That is my opinion. Thank you.
Thank you so much. Any other comments on that, panelists? Panelists, over to you. Okay, let me move on to the next one. Then the other question that we have is by Laxon, it's about the retrospective effect. I think TC did clarify that unless if there are further affirmations needed, Titi Laxon is asking that the bill does not have retrospective effect. Therefore, the 5 years for courts to expire for re-registration should start counting from the date the bill is promulgated into law. Titi, please clarify. I assume, Titi, you clarified this when you talked about the effective implementation date. Can you kindly confirm that?
That is true. You will notice that in the amendment bill or the Labor Amendment Act of 2015, the provisions were specifically to be effective with a retrospective at a retrospective date. But with this one, unless in the act, in the finalized act, the legislature is specific on the time that the bill will be effective from. Who take that it will be effective from the date of promulgation. So as of now, there is no retrospective provision to the application to the effective date. So the time to calculate the 5-year period will be from the date of promulgation.
Thank you, Titi, for the clarity. Then we have a comment from Sandra. The truth is that the bill on maternity will be negative on women. What we need to do is to lobby the government to provide maternity cover from Social Security, as should happen and is the tradition in most countries. Thank you for that. And then Brian is asking, I would like to know what considerations were made in setting the 12 months time frame for contracts. Panelists, if you may just, do you want to tackle that? Over to you.
Yes, sure. Maybe what I'm thinking is there was a rampant behavior in the employers whereby they would just peg the contracts of employment on fixed term, and you would find that employers would have employees on 6 months contracts, 10 months contracts, whereby they are trying to avoid retrenchment packages and avoiding having employees for a long period of time in the employment sector, so that they would avoid maybe issues like pension and other obligations. So you would realize that the act is alive. The legislature is alive to that that problem within the industries, which is why you've seen that they have pegged that if in any undertaking, majority of the employees are on a fixed term contract, then those contracts would be those contract employees would be entitled to minimum retrenchment package. And also they have stated that every contract that is below 12 months and not covered in the exceptions would be a contract without limit of time. They're just trying to curb or to avoid that mischief where employers would just go on and hire employees for a short period of time to avoid obligations at the expiry of employment contracts.
Thank you, Titi. Then the last question that is available is from Gift Marunda. At what stage is the bill in Parliament? Panelists, over to you.
Without much information, since the second draft of the bill has been gazetted, I would like to believe that we are now at the second stage, second stage of the bill, where it will be voted into act and then sent for assenting by the president. So I think we are at the second stage of the bill.
Okay, thank you so for that. Then there's the last question that have come through. Can there be clarity regarding compensation for those who have resigned from the workplace? I think it's Cleopas, yes, from employment, and those whose fixed contracts come to an end. Are employers mandated to compensate such in the new bill?
Let me say that where an employee has resigned or they've been dismissed after a disciplinary hearing, they would have caused their own loss of employment, and therefore they do not qualify to be paid the compensation for loss of employment, that 1 month for every 2 years worked.
Okay, thank you so much, Gladys, for that. Ladies and gentlemen, unfortunately, for the sake of time, we have to close the question and answer section. You can kindly email us via the EISAZ contract details so that we can clarify your questions. And I just want to thank you all for your time and effort that you have dedicated to join the session. This is very critically important, especially from a stakeholder perspective. And looking at the numbers that have joined the session, this is actually amazing. And I'm personally impressed by the passion just to get the knowledge about the new labor amendment bill. So my takeaway message is that, we need to have such consultative forums to discuss, to sort of like decipher, to demystify the implications of some of these amendments in terms of how we manage people, because the management of people is not only about the regulatory aspect. We also need to take into account the humanistic aspect again. To what extent do we bridge the gap between rhetoric and reality in terms of just managing the labor relations landscape? So it's very crucially important that we have such discussions. And I'm personally impressed once again by the presenters, the panelists, and EISAZ or protocols observed for just putting up this platform. I look forward to another session where we get to evaluate, when this bill is passed into law, what has been the implementation and evaluation? What are the logistical challenges people are facing? So ladies and gentlemen, thank you so much. All of your participation and your time is much highly appreciated. Mr. Riziwa, over to you.
Thank you very much, Doc. Thank you once again, Doc, for the splendid job. On account of our time, I'm going to request Mr. Ernest Jackson, Human Resource Manager for Pump and Steel Supplies, who is also the Vice Chairman of the Engineering Iron and Steel Association of Zimbabwe's Western Region, to give us a vote of thanks and a closing prayer.
Thank you very much, Mr. Chair. Jennifer, thank you so much for holding fort in an amazing way. It would have been refreshing if the conference was closed with a beautiful voice as that one that was moderating, but you'll have to bear with me just for a few minutes. Our Director of Ceremonies, distinguished guests, ladies and gentlemen, I'm extremely humbled to have been asked to convey a vote of thanks on this occasion. I, on behalf of Engineering Iron and Steel Association of Zimbabwe National Executive Council, the Fraternity of the Labor Relations, here present, and on my own behalf, extend a very hearty vote of thanks to all of you for gracing our conference. Ladies and gentlemen, as we end today's event, I would like to say thank you all for joining the conference. Your presence today shows a strong commitment to labor law reform in our beloved country, Zimbabwe. In particular, I would like to express my sincere gratitude to our speaker and panelists for sharing their expertise on the Labor Amendment Bill with us. I took note with great interest of your valuable interventions. As a big thank you to our main speaker, Tsitsi Mazikana, for a profound presentation on key aspects envisaged in the bill, which I have no doubt will lead to proactive strategies being put in place at our various enterprises and institutions to align our collective bargaining agreements, employment contracts, and human resources policy with the new legal provisions of the bill as a sail through in Parliament and gets enacted into law by His Excellency President E.D. Mnangagwa. As mentioned by the Director of Ceremonies earlier on, Tsitsi had to set aside a pressing commitment at the Supreme Court to be here with us today. Thank you very much, Tsitsi. We appreciate your time. We appreciate your commitment to our cause. And the issues that you raised that we've taken note of are the fixed term contracts, the controversial maternity leave issue, which the late President Robert Mugabe once said, we can't expect our women to have children for us and then punish them for having children. So this is going to be an interesting debate in the next couple of days. The sexual harassment policy, the code of conduct, and the paid educational leave are some of the issues that Tsitsi touched on. I would also like again to thank Dr. Nzonzo for great moderation, time consciousness, always being on the ball, and meticulous and faultless moderation. Further, we are grateful to all the panelists who made such an insightful and effective discussion, which I would want to describe as very educative and informative. Nothing more, nothing less. Ladies and gentlemen, allow me to extend our gratitude to Mr. Moment Bebe, who for doing justice and further breaking down Tsitsi's presentation on the amendments and zeroing in on the sexual harassment aspect and warning employers to avoid the appetite to deal nicodemously with issues and amendments that that have been raised in the bill. We also wish to pass our warm thanks to you, Mrs. Mpemba, for an on-point debate which gave the audience an eagle's eye on key issues in the bill. Another heartwarming gratitude goes to Patrick Mucho for an excellent discussion and pinpointing and discussing the unintended consequences. Also a great thank you to Mr. Marara for a valuable contribution to the conference. Frank undoubtedly opened our eyes on areas to do with the questions, i.e. the retirement age, and also raised and interrogated some areas of the amendment that may need our attention to look at them a little bit more closely. Lastly, we are also grateful to Mr. Maedzenge for an inspiring discussion. And distinguished guests, ladies and gentlemen, I would like to thank you all for your active participation, open dialogue, and I look forward to continuing beyond this event, the very stimulating and instructive exchange of ideas we had today. I trust that you all will take home further inspiration on how to foster the necessary changes that will be brought by the labor reform, but by the law reform. I certainly will. Finally, I would like to take the opportunity to say thank you to the Director of Ceremonies, Mr. Matthias Rozier, who is the Secretary General of our association, for the support and guidance he has extended to all of us as this educative, informative, and insightful event. Thank you so much for driving the event to the expected and desired destination and actually above. Please keep up the good work. Ladies and gentlemen, once again, I would like to prefer our warmest gratitude to the Secretariat team that is led again by Mr. Rozier for a job well done in putting in place and proper planning and logistics to make the conference a success. They say that only time where success comes before sweat is in the dictionary. Thank you, Mr. Rozier, Kudzim Tlanga, our membership and admin officers, and Mrs. Mateko, our human resource specialist. Thank you very much to each and every one of you that have made an effort to attend this important event and make it such a success. May God bless you and thank you again. May I ask us to bow our heads as we do the closing prayer. Let us pray. Father, we'd like to thank you for such a special event and a successful event that has been hosted. We thank you for each and every member that has been represented here present. Father, we just want to pray for our country and our industry. We call upon the Holy Spirit to flow around our industry. Father, we call upon special blessing upon even our employees in the sector. We call upon even the business in the sector, my God. May your presence grace all these areas, my Father. Father, we'd like to thank each and everyone who was here present in this presentation. I pray a special blessing upon them as they return to their works. May the work of their hands be blessed, and may everything they touch be successful. We pray all this and give all glory and honor to you. In Jesus' mighty name, amen.
Thank you.
Thank you,
very
guys.
much.
Thank you.
Thank you.
Thank you, Tim.
Thank you very much, Mr. Jackson. Ladies and gentlemen, we have now come to the end of our program. Please stay safe, continue to enjoy your day. Until we meet again, may the Almighty God bless you. Bye.